Unfortunately, the Patent Office website is very confusing. So they have a fee schedule page, but the fee schedule page is actually very, very difficult to navigate and very difficult to understand because they split up the fees in a really complicated fashion. So you have your basic filing fee, you have an examination fee, and then depending on if you have extra claims, there might be extra claim fees. USPTO.gov site has a schedule page that has a schedule of fees. Okay, so if you're representing someone before the patent office, or if you're an inventor filing yourself, the first thing that you're going to want to do is you're going to want to ascertain what kind of entity you are, because the type of entity will dictate the fees that you're going to pay for various patent office fees, including filing. So there's three types of entities for filing fee purposes. There's what's called undiscounted entities, small entities, and micro entities. So undiscounted entities you can think of as matters of large concerns. So for example, a large corporation, a company having more than 500 employees, these are matters of large concern. And the companies that are large are going to pay the undiscounted rate, right? Kind of makes sense. Bigger company, more resources, they're going to have to pay more in order to go through the patent process and file their applications. Now, a small entity, usually a company less than 500 employees, is going to qualify for the small entity fee. Now, it's really simple to remember. So the three fee structures: undiscounted, small, and micro. All you do is you cut the fees in half generally. Now there are some exceptions, but generally the undiscounted rate is going to be, the small entity is going to be half of the undiscounted rate, and the micro entity is going to be half of the small entity rate. In other words, a micro entity is usually 1/4 of the large undiscounted entity rate. So again, the first step is figuring out the size of your entity. Now, I would describe what an undiscounted entity was. That's a matter of large concern. So your typical large corporation, your publicly traded company having more than 500 employees, they're going to qualify as undiscounted entities, and they're going to pay the higher fees. Now, what is a micro entity? So to qualify as a micro entity, generally the way people qualify is based on income of the prior year. So if your income was below a certain amount in the prior year, then you will qualify as a micro entity. Now, I like to caution people about two things. One, it's very important that you elect the right fee. So you don't want to pay thousands and thousands of dollars, obtain a patent, only to find out that your patent could be in jeopardy because you paid the micro entity fee when you shouldn't have, and should have paid the small entity fee. Now, I think one trap is if you're in a community property state like California. You have to remember, if you're an inventor and you're married, so if you're married and you have to incorporate, say, your husband's income or your wife's income, and make sure I say make sure you're conservative. So it's always better to pay slightly more for the small entity and be safe, knowing that you're at least paying the conservative fee amount. Now, here's the big gotcha that you have to be really careful with, both for small entities and micro entities. If you're filing as a small entity, but you have an obligation to assign your application to a large entity. For example, let's say you're developing new technology and you are already licensing that technology to a large company like an IBM or Microsoft of the world, then you actually don't qualify as a small entity or even a micro entity for that matter. So it's very important. If you have an obligation to assign to an undiscounted entity, then you need to be paying the higher entity fees. So that's a very, very important thing to remember, and a big gotcha. Now, the other fees that you really need to be careful with are fees for claims. Generally, just remember, 20 claims total with 3 independent claims, that is what your filing fee is covering. If you have more than 20 claims or more than 3 independent claims, then you're going to have to pay additional claim fees. Now, why is it important that we get the fees right? Well, if you don't get the fees right, then after you file your non-provisional or provisional application, and you have the wrong fee amount, you're going to get what's called a notice of missing parts. So the patent office is essentially going to say right from the get, hey, you didn't pay enough, and so we're going to issue you this notice. And not only do you have to correct it to avoid your application from going abandoned, but you also have to pay a fee surcharge. So they basically charge you a penalty for filing the necessary fees late. So it's a really good idea to pay the right fee amount from the get. And obviously another problem is that, let's say your application goes abandoned, then that's a real problem. Say you for some reason forget to handle paying the surcharge, or forget to even respond, your application is going to go and abandon, and now you have to pay a petition to revive. So the takeaway is, make sure you pay the right fee amount and get it right, because you don't want to have to deal with a notice of missing parts, and you also don't want to have to deal with having to pay the surcharge. So it's always better to just make sure you pay the right fee amount. And again, I highly encourage you to be conservative. And if you're right on the edge between a micro and a small, and sometimes it's safer just to pay the extra amount, especially when you look at the total cost of what it's going to be at the end of the day to get an issued patent. It's relatively minor compared to the filing fees. So it's better to err on the side of caution, be more conservative, and classify yourself as a small entity. And again, remember, the Patent Office doesn't provide a lot of guidance on this in calculating the gross income determination. And so again, be conservative. If you're in a community property state, I would highly encourage you to take your wife's spousal income, wife or husband, into account. And again, the reason to do this is to not jeopardize the validity of your patent after issuance.